Hi, this is Ed Sullivan and Marco Berti on our series of Retaliation. Mark, I want to talk to you about the Fair Labor Standards Act, specifically the anti-retaliation provision of the Fair Labor Standards Act. There's a lot of debate, or there has been, about what constitutes protected activity under the FLSA. What about an internal complaint? Obviously a complaint to the Department of Labor would be sufficient, but what about an internal complaint?
Well, a couple things, Ed. Backing up to 2011 in this St. Gobain-Caston case, the U.S. Supreme Court said an oral complaint can be protected. But the Supreme Court, you know how they do. They don't like to rule broadly. They didn't decide whether the oral complaint had to be to the government, in other words, the Department of Labor, or if an internal complaint could be good enough. They just said an oral complaint can be covered, which that was a question because the anti-retaliation provision uses the word filed. So employers were saying, no, it has to be some document filed somewhere. So then the question is still out there, the one you just asked, is what about an internal company complaint? Is that covered, or does it have to be the DOL? And almost every court to address the issue has held an internal company complaint, so long as it's reasonably specific, doesn't have to specifically say FLSA, but notifies the employer of an overtime allegation that would be cognizable under the FLSA, it's protected. Fourth Circuit ruled that way earlier this year. The Fifth Circuit ruled that way in Hagen versus EchoStar a few years ago. Every district court and every court of appeals has ruled that way, save one. The Second Circuit Court of Appeals, which is normally considered fairly pro-employee, has said in the past, no, an intra-company complaint is not sufficient. And it post the U.S. Supreme Court case of St. Gobain, a district court in New York continued to follow that. So the rest of the country, probably an internal complaint, so as long as it's specific enough, is covered. But in the Second Circuit, probably not covered.